Tonight, Attorney General Godfred Yeboah Dame tears into Speaker Alban Bagbin for allegedly procuring the services of Thaddeus Sory as lawyer for the Parliamentary Service without approval from the Public Procurement Authority.
That you cannot use a crime to defend a clear unconstitutional action by yours. So indeed, you are engaged in an unconstitutional action and you are using, with all respect, the commission of a crime to further that unconstitutionality. That is wrong.
We have details plus speak to a private legal practitioner on this raging controversy plus what we are learning about the situation. Tonight, the Attorney General and Minister for Justice Godfred Yeboah Dame says the Speaker of Parliament has illegally procured the services of Thaddeus Sory as a lawyer for Parliament and the Parliamentary Service. This became an issue in court yesterday when the Supreme Court sat on a case challenging an earlier ruling of the court after the Speaker Alban Bagbin declared 4 seats in Parliament as vacant. We'll hear more on this story shortly, but first listen to the AG Godfred Yeboah Dame challenging the inclusion of the Speaker to the suit being heard and how the lawyers had been engaged.
There are 2 points that arise out of my reference and brief submission to the court. And I made them. 1, it is a matter for the interpretation of the Constitution. Respectfully, as I earlier on submitted, in the matter involving the interpretation of the Constitution, there's even no such party as a party who has an interest in the matter, apart from the entire state. And respectfully, it is not for nothing that the Constitution makes the Attorney General the defendant in all actions involving the government, an arm of which is Parliament. So my submission is that
and the Constitution. And the Constitution,
yes.
In all constitutional actions, the Attorney General is required
to be the defendant.
Be a party.
Yes, be a party. And respectfully, the point I make is that indeed the reluctance, with all respect, of the first defendant.
Can we get to know the objective?
Right. That first and foremost, if the first defendant is unwilling, with all respect, to file processes to enable the court to complete the case by Friday, my submission is that the first defendant is not even a proper party to the proceedings before the court. And his absence will not derogate from the court's ability to proceed with the hearing of the matter. Because he, the first defendant, has no personal interest in the proceedings before the court. Indeed, it is even improper for the first defendant to have been joined to the action. The proper defendant should have been only the Attorney General. The second submission I make is actually linked with the first. Especially if a party who is a public officer is joined to a constitutional action involving the Attorney General, that party, if the court allows it, will have to procure services lawfully. My submission is that even counsel for the first defendant has not been lawfully procured. He has no lawful mandate to represent the first defendant. The procurement of all goods, works, and services in this republic must be in compliance with the Public Procurement Act. Section 14, subsection 1, requires the procurement of even the Attorney General, with all respect, even the Attorney General, when the Attorney General is procuring service of a lawyer, the procurement goes through PPA approval. Even the Attorney General, when procuring service of a lawyer to represent the country outside the Republic of Ghana, in a high court in, say, London or New York, will have to be subject to PPA approval. My reasonable submission is that the first defendant's counsel, I've tolerated him for no, and now he's even seeking to use the fact that he doesn't have instructions of the Speaker to continue as an excuse to delay proceedings.
So this is what happened in court. Now, after that particular encounter, a letter has surfaced in the media from the PPA rejecting an application to single source Sory at law, the law firm of Thaddeus Sory, as a solicitor on retainer for Parliament. My colleague and Parliamentary Affairs correspondent Kweku Asante joins me in studio with details of that particular letter. Kweku, first, what does the letter say?
So this letter is actually dated the 12th of December 2022, so close to 2 years now since this letter was addressed to the clerk to Parliament. It would appear the clerk had written to the Public Procurement Authority seeking approval to engage Thaddeus Sory as lawyer for Parliament and the Parliamentary Service. Let me read specifically what the letter says. It says, we make reference to your letter, this letter that I referenced, dated 15 November 2022, on the above subject. That is, request for approval to procure the services of external solicitor to support Parliament and the Parliamentary Service through the application of a single source method of procurement. And then PPA says, at the 31st board meeting of the 5th board, held on Thursday, 8th December 2022, the board could not approve your request to use the single source procurement method to engage Messrs. Sory at Law as an external solicitor to support Parliament and the Parliamentary Service at a retainer fee of 5,000 cedis and specific fee for conduct of constitutional cases in the Supreme Court at a fee not exceeding 300,000 Ghana cedis. The board notes that since the Attorney General is the principal legal advisor, the board is of the considered opinion that the Parliamentary Service should continue to use the services of the AG in all legal matters. It comes on usual cooperation, signed by Frank Mante, the CEO of the Public Procurement Authority.
Well, quite instructive there, but it also has a lot of nuances, and it depends on the lawyers and what they do make out of it. But Kweku, you have been speaking exclusively to the AG on this particular matter of Alban Bagbin allegedly procuring the services of Thaddeus Sory illegally. What has he been telling you?
So, right after the court case of yesterday, I did catch up with the Attorney General, Mr. Godfred Yeboah Dame, and I sought to find out from him the basis for the claims he had made in court that the services of Messrs. Sory was not procured properly by the Speaker of Parliament. And he speaks, and I also reference this Public Procurement Authority letter, and says that it is clear to him and his mind that the Speaker of Parliament has illegally and actually unlawfully procured the services of Mr. Thaddeus Sory to represent him in these constitutional matters. He goes on to actually make the point that the Speaker of Parliament is committing a crime by going ahead to use this crime as a basis to come to the Supreme Court to fight a supposed illegality. Let's listen to the AG, then we can talk about some of the things we've been hearing from the persons we've been trying to get some text from as to this engagement.
I think it was a matter that was properly brought up, yes, because as I indicated to the court, the procurement of all goods, works and services of any person with public funds must be with the approval of the Public Procurement Authority. So it's a matter that is very important, and indeed, yes, we raise it.
In the Megacha case, the court stated that when it comes to issues where Parliament and the AG's office are cross purposes, they can hire different lawyers.
As I said, in constitutional case, there's nothing like a person have an interest in it. What interest does the Speaker of Parliament have in the interpretation of the Constitution? So there's no interest, no personal interest of the Speaker of Parliament. And that's the point I sought to make. That indeed, when it comes to constitutional actions, the most important interest is the true and proper interpretation of the relevant provision of the Constitution. And that is it. So it's not as if a person has a personal interest in it. And if that's the case, as I indicated in some cases that I cited, it is actually a proper interpretation of the Constitution by the Supreme Court that is most important. I mean, as I said, I've always tolerated the Speaker of Parliament and his representation, even though I know it's not lawful. And of course, it is not. You see, and the point must be made. It is not an attempt to prevent the Speaker from having representation. If the Speaker wants to have a lawyer, the Speaker must procure the lawyer lawfully. And then, as I said, the Attorney General, even when he's seeking the service of a lawyer to represent the government in cases outside the country, in foreign court, goes through PPA approval all the time. Even the Chief Justice, the former Chief Justice, Yeboah, who was, with all respect, using the services of Thaddeus Sory, had to go to PPA approval. And I know for a fact that he has not received any PPA approval. And so he's in flagrant violation of the provisions of the law, and that is what we sought to do.
And why did you leave? You did not raise it again. The Chief Justice came back and did not mention it again.
Well, that's up to the court. You know, I do not quarrel with the court at all when the court decides to either defer a ruling or maybe decides not to rule on it. And of course, all rights are also reserved in us to take it up further. A breach of the PPA Act constitutes a crime. And my contention is that you cannot use a crime to defend a clear unconstitutional action by yours. So indeed, you are engaged in an unconstitutional action and you are using, with all respect, the commission of a crime to further that unconstitutionality. That is wrong.
Attorney General and Minister for Justice Godfred Yeboah Dame speaking to Kweku Asante. And Kweku, we've been trying to make a bit of a digging to understand what exactly is happening. You've been speaking to someone who is also tied into this. What have you been learning?
According to our sources, I mean, there are some persons who really are familiar with these matters. They do not believe that the Attorney General is right on this matter. Okay. In fact, they reference us to Article 124 of the 1992 Constitution, which talks about the Parliamentary Service as a whole. And they believe that the reading of the letter is instructive, because if you look at the request that went from Parliament, it requested approval to procure the services of Mr. Sory for Parliament and the Parliamentary Service. And then in the rejection letter, the rejection stated that the Parliamentary Service should go ahead and use AG. So that person's reading of the PPA letter says that the PPA was only rejecting the use of Mr. Sory for the Parliamentary Service. And the distinction that has sought to be made is that Parliament is different from the Parliamentary Service. And that is true because the Constitution treats them differently. Okay. Parliament is discussed differently in the Constitution, and the Parliamentary Service discussed differently. And Parliamentary Service is also headed by the Speaker, but it's made up of the clerk and the staff of Parliament. Whilst Parliament, strictly so called in the Constitution, refers to the House, being the 275 members and the Speaker presiding. So this person has sought to make the distinction and say that that is the difference. Okay. This person also claimed that Mr. Godfred Dame's objections are simply unfounded, to the effect that the Speaker of Parliament has actually followed whatever existing legal processes to have actually procured the service of Mr. Sory. They refer us to, for instance, if you go to the Speaker of Parliament's office, there are so many other persons who also work there who are not necessarily a part of the Parliamentary Service. There's a counsel to the Speaker. There's the Speaker's Chief of Staff. There's a panoply of officers who work in the Parliament of Ghana, for which reason these persons are, this source is arguing that the Speaker of Parliament has simply not breached any regulation. And as far as this person is concerned, they are ready for the Attorney General. If he's so minded to take this matter on at any appropriate forum, they will be there to actually respond.
There's a lot more we have on this particular story. This is Top Story, brought to you always by Telecel, connecting energies and holding insecticide spray and coil. Well, let's bring in a procurement expert, Collins Ajiman Sapon, into the discussion. We also have lawyer Martin Pebu as well in this. Collins, grateful for joining us here. First off, I mean, what do you make of this particular story, that the AG is alleging that the Speaker of Parliament procures the services of, a lawyer illegally?
Okay. From my side, when you look at the law, we have bodies, all the bodies of government are what we call procurement entities. Okay. Hello?
Yeah, you're on, sir.
Yeah. We have procurement entities. And when you look at the law, Schedule 1, we have what we call special constitutional bodies. Okay? And these bodies are the legislature, judiciary, Council of State, and Bank of Ghana. They have been set up as special constitutional bodies within the procurement law. And therefore, parliamentary services or the legislature is a procurement entity, right? So now, in the law, to apply single source, and today let me have the opportunity to explain the difference between single source and sole source. Single source means that you have a lot of service providers within the market, by situations calls for you to use one. And sole source is you can get the services from only one person or only one service provider. So this one is more single source because we have a lot of lawyers and the Attorney General. So if you write, and the law says that, Section 40, when you want to apply single source, you need to write to PPA for approval. Now they went to PPA, and PPA turned it down. That use the services of Attorney General for whatever legal services that you want. So that ends it. So it means that you cannot do single source again. So my advice, or if I was their consultant or something, I would have recommended that if you still want to use a private legal service, why don't you go through the competition? So then you can invite 2, 3, 4 lawyers or service providers, then you select from one. But if PPA turns down your request for procurement as a single source, and you still go ahead and engage the services of one lawyer or a person or legal services, it is a total breach.
But doesn't it matter that in the response from the PPA to the letter that that came from Parliament, it says in the concluding part that the board noted that since the Attorney General is the principal legal advisor, the board is of the considered opinion that Parliamentary Service should continue to use the services of the AG in all legal matters. Now, mindful that it says Parliamentary Service, it didn't mention Parliament. Is it not instructive that because you didn't include Parliament, of course, then you are saying that Parliament can go ahead and engage a lawyer?
I'm coming here. You see, when you come to Schedule 1B, which sets up the entity tender committees of these special constitutional bodies, the chairperson of the legislature for as entity is a chairperson is to be appointed by the Parliamentary Service Board. So what's the difference between the Parliamentary Service Board and the legislature and all that? So even the head of the procurement entity or the chairperson of the procurement entity, tender committee, is appointed by the Parliamentary Service Board. And therefore, taking Parliament away from the which body is the legislature? And which body is Parliament? So we need to situate, when it comes to procurement, they have a certain committees. And I'm even hurt as a professional because where does Public Accounts Committee sit? It sits in Parliament. And 80% of the cases that comes to Public Accounts Committee are procurement infractions. So what is happening? I'm hurt as a professional. I'm hurt as a professional. You passed the law in 2003, you amended it in 2016, and the same body, the lawmakers, the legislature, is breaching the whole thing. It's hurting as a professional. So we talk, wanting ethical things, and look at the bodies that are fighting.
Okay.
PPA
so Mr. Sabon, I want a clarity here. I want some clarity. So are you saying that the PPA that wrote this letter, to refer the letter from Parliament to say that, we approve your request. Okay, says the board could not approve your request to use the single source procurement method to engage Mr. Sory at law as an external solicitor to support, and watch this, Parliament, that's one, and the Parliamentary Service at a retainer fee, blah, blah, blah. And then it concludes by saying that the Parliamentary Service should continue to use the services of the AG. Mind you, it didn't bring in Parliament here. You're saying Parliament, therefore, should see itself as part of the Parliamentary Service and so cannot engage a lawyer because the PPA did not mention it.
Hello.
Yeah.
The first thing, it is the Parliamentary Services that wrote to Public Procurement Authority. Is that not?
Yes.
Is that not? So if Parliamentary Services rise to PPA, seeking single source, so are they saying that if granted the PPA have given them the approval, is it not the same Parliament that is going to use the single source? It is. The Parliamentary Service, I'm not a lawyer, but I know the laws around procurement. The Parliamentary Services is a procurement entity under the law, and they work for entire Parliament. And you know that the legislature is like a whole company. And the people who do the running around, the procedures, running around of Parliament, even I had the opportunity to train some session of the Parliamentary Service. Their stores, everything. The boss, the CEO of Parliamentary or parliamentary services or the legislature is the clerk of parliament. So the clerk of parliament is in charge of the day-to-day administration of parliament.
Okay.
And all these people work under him.
Okay. All right.
So I see parliament as a procurement entity run by people like the clerk. And the clerk, you see them but the day-to-day management of parliament is under the clerk.
Okay.
So
all right.
please, you don't dissociate the parliament from parliamentary services.
Okay. Stay on with me.
I think that the bridge needs to be pushed because it's very painful that now in Ghana, people are saying that power, when we are talking about power, you are talking about law. And it's getting into every space. You speak to a politician and he will tell you, do you know where the power lies? And all our laws are being trampled upon.
Okay.
You need to watch this. It's painful for the profession.
Stay with me. Let me bring in a legal practitioner who would help us understand the legalities. Martin Pebu is with us on the line. Martin, I'm grateful to you for joining us here. Now, help us understand, is Parliament different from Parliamentary Service Board, or it's the same?
Oh, obviously, they are different entities. Obviously, they are different because the Constitution itself talks about who Parliament is. And the Parliamentary Service is different because they will tell you that Parliament is made up of a certain number of parliamentarians and the Speaker. So you see that with that definition, that is not the Parliamentary Service Board. You see, what we should look at is that if there is a lacuna in the law, let's tackle that. But let's not try to subsume Parliament under Parliamentary Service. Kweku read the other provisions, right? So there's no way or there's no space for us to say that Parliamentary Service is the same as Parliament. No, they are different. The parliamentarians are not part of the Parliamentary Service. Even from the word service, you see that there is that distinction. You even come to the judiciary. The Constitution makes it clear. There is the judiciary, then there is the judicial service staff.
Okay.
So that is the difference between them.
If you check on Parliament's website, it says the Parliamentary Service exists to facilitate the work of Parliament through the provision of support services to the House, including its committees and agencies for the purpose of ensuring full and effective exercise of the powers of Parliament. If that is the case, shouldn't a lawyer for the Parliamentary Service be the same servicing Parliament?
Not at all. Not at all. Okay, so let's go through this. So as I stated earlier, under Article 93, this is why it says, 93.1, there shall be a Parliament of Ghana, which shall consist of not less than 140 elected members. You see it? Yes. And then blah, blah, blah. So that's Parliament. When you come to the Parliamentary Service, so you hear them talk about the clerk, deputy clerk, the ushers, the marshals, the people who assist. They are not mentioned in Article 93. 93 is very clear. There shall be a Parliament of Ghana, which shall consist of not less than 140 elected members. Then there is also the provision for a speaker, etc. I think, you see, let's do this. We are not bound to try to push Parliament under Parliamentary Service. Everything there is a lacuna, please, let's take steps to bridge that lacuna, to solve it, but not to stretch it too much. There are many Supreme Court decisions that tell you that. You see, you can have a law that is undesirable, but don't think that the undesirability should equate to unconstitutionality. No. The two cannot be the same. If there is a lacuna, let's deal with it expressly.
But some people will find it hard to deal with the fact that if the Parliamentary Service, as they say, is to facilitate the work of Parliament, and of course, the same lawyer that services the board should be the same person servicing the House itself.
No, there's no logic in it at all. There's no logic. So let's go over. The board it's made up of what? The speaker, the clerk, the other appointed person, right? They help to manage. But issues of management, there can be issues of labor, etc., that the board needs to deal with. Get buildings, get health insurance for workers, all those things. You need lawyers to help.
Okay, but
staff.
So if they are different and the speaker is procuring, let's say for now the issue at hand is the lawyer. If the speaker is to pay this lawyer with public funds, is he not supposed to get approval by the PPA explicitly to engage this lawyer?
Ordinarily, yes. But if there is a lacuna, let's take steps to amend. Because once you don't mention Parliament itself, then and also the reason we're doing this is that remember that the Parliament is an independent arm of government.
Sure.
So you don't want to do any interpretations that will seek to reduce the authority of Parliament. We already have enough trouble in the Supreme Court. So let's not do any other interpretation that will add to the woes. We are trying to build a democracy. What does it take to amend? Because we are looking for accountability, right? Yes. So by all means, anytime you talk about accountability, I'll be one of the first to support. So I don't have a problem. But when you say writing parliamentary service is the same as saying parliament, that one is a challenge.
Okay. All right. So how do we deal with this issue that we have now? Not the speaker being accused of procuring the services of Sory at law illegally. How do we address it going forward?
Yeah. So that matter was not even properly raised. It wasn't properly raised because you see, when you go to court, we have what we call an application. If you want to raise these matters, you write an application, like an application for a job, but of course our procedure is different. Then it will be served on the speaker and his lawyer, Thaddeus Sory. Then they will answer. But what Godfred Dame did on the occasion was ambush. You see how the Supreme Court dealt with it nicely.
Okay.
You see, they didn't even dignify him with a response. Yeah, because yesterday he was just talking too much. Said so many things. Yeah, what they did was just to ignore him because he doesn't realize some of these things. So he's done them 1-2 days. So the best the court will just is to just ignore it.
Okay.
Can you imagine you ask your teacher a question in class and teacher doesn't even give you an answer? It tells you that what you said that it's not something that should be dignified with a response.
All right. Collins Ajaman Sapo, you are a procurement expert. How should this be dealt with? Where we are now, where the speaker has been accused of using the services or procuring the services illegally.
You see, are we being told that the Parliament, the 275 parliamentarians with their speaker, are we going to create a procurement entity for them? No. That is why the Parliamentary Services Board, from the lawyer, the speaker is part of it. So when it comes to, let's say, the presidency, the executive, okay, the chief executive officer who run the day-to-day management of the executive or the presidency is the chief of staff, okay? So the chief of staff is the one running the services, procurement of service, staff keepers, payment of staff, and all that, okay? Even equipping that place with human beings, okay? Then you move to judiciary. Judiciary, we have the judges, the top one, with the chief justice. They sit there. It's the judicial services that manage their day-to-day operations, okay? The court, when you go to the court, the chairs are in the court. It is not brought by the chief chief justice. It will go through the judicial services. That's where they have officers, civil servants. There you get a procurement head there. You have head of finance and all there.
Okay.
When you come to Parliament, it's also the judicial parliamentary services.
But since Parliament applied, or the Parliamentary Service applied to the PPA for approval, yes,
for their bosses.
Exactly. Would you recommend a retrospective approval from PPA for this? retrospective
No,
approval.
It's a breach because the letter it was 2002, right? The letter from Parliamentary Services to PPA. The letter is not today.
Yes, 2022. Yes.
Thank you. So it was asked then, okay, and they turned it down. So today, if you are engaging Sory at law, and you just ignore that approval, that's why I'm saying that if I was the one consulting for them, I would have gone to judicial services and tell them that parliamentary services and tell them that, look, as for the single source, the guys have turned it down. And once your single source is turned down, it means that come and compete.
Okay. All right.
The PPA didn't tell them don't secure any services. So he advised. He said that use Attorney General's office to do your procurement. I'm not giving you the single source. Now, don't do it. So if you still want outsider, compete.
Okay. I'm grateful to you.
You would have gone through it.
I'm grateful. Collins Ajiman Sapoin's procurement expert. This has been Top Story, brought to you by Telecel, connecting energies, holding set size spray and coil. Enjoy holy sleep. Up next is News Night with MFA Apau.